They walked into that courtroom like they already owned it. The HOA president sat front and center, arms crossed, whispering confidently to their attorney as if the outcome was already decided. Their lawyer stacked papers neatly on the table, thick folders, color-coded tabs, spreadsheets printed in bulk. It was clearly meant to intimidate. This wasn't their first time suing a homeowner, and it showed. When the judge called the case, the HOA attorney stood up fast, voice sharp and rehearsed, announcing that I owed years of unpaid dues, late fees, penalties, and administrative costs. According to them, the balance had ballooned into a number that didn't even sound real anymore. They spoke like it was open and shut. Like I was just another homeowner who hadn't paid attention and was about to get steamrolled. But something felt off from the start. As the HOA attorney explained their records, the judge began flipping through the documents slowly. Not nodding. Not reacting. Just quietly reading. The lawyer kept talking, too much, actually, explaining how the HOA's internal accounting system tracked payments, fines, and interest. He pointed to summary pages, balance sheets, and neat totals highlighted in yellow. It all looked professional on the surface. Then the judge looked up and asked a calm, almost casual question that instantly changed the temperature in the room. Where are the original financial records? The attorney froze for half a second too long. He cleared his throat and said the HOA had provided summaries of the accounts, generated from their system. The judge raised an eyebrow. No bank statements, she asked. No deposit records. No receipt logs. The lawyer tried to explain that the HOA's software was reliable and that the summaries were industry standard. The judge didn't interrupt, she just waited. The silence stretched. Suddenly, those thick folders didn't look so impressive anymore. I could see the HOA president shifting in their seat, the confidence draining just a bit. When it was my turn to speak, I didn't argue loudly or emotionally. I simply pointed out what had been bothering me for months. My payments had been made, but they appeared late on the HOA's ledger. Fees would appear without warning. Balances changed from one month to the next with no explanation. I said I'd asked for itemized records before, real records, and never received them. The judge looked back at the HOA's documents, then back at me, then back at the HOA attorney. Her pen stopped moving. That's when the HOA president made a fatal mistake. They interrupted. They leaned forward and insisted that the numbers were accurate and that homeowners like me were always confused about how dues work. The judge shut that down instantly. She reminded them, firmly, that only one person speaks at a time in her courtroom. Then she asked the question that clearly wasn't in the HOA's plan for the day. Has this association ever had an independent audit? The attorney hesitated. The HOA president looked at him. He looked back at the judge and gave an answer that landed like a dropped plate. No, Your Honor. Not a forensic audit. The judge leaned back in her chair, folded her hands, and stared straight at the HOA's table. The confidence was gone now. Whatever this case was supposed to be, it was no longer that. And I could feel it. This wasn't heading toward a routine ruling anymore. This was just the beginning. The judge didn't say anything right away. She just looked down at the paperwork again, slowly flipping back and forth between pages like she was searching for something that should have been there, but wasn't. The HOA attorney tried to fill the silence, launching into another explanation about how their accounting software automatically calculated balances and applied fees. He talked faster now, less confident, repeating phrases like standard practice and internally verified. The judge finally held up her hand. I understand how software works, she said flatly. What I'm asking for is proof. The room went quiet again. She began pointing out inconsistencies aloud. Payments listed as received weeks after my bank records showed they cleared. Late fees added on dates that didn't line up with any notices. Totals that jumped by hundreds of dollars without explanation. Each time she asked for documentation to support a charge, the HOA attorney flipped pages, hesitated, and redirected back to the same summary sheets. No deposit slips. No bank statements. No receipts. Just numbers pointing to other numbers. The judge's expression didn't change, but her tone did. It sharpened. When it was my turn again, I explained how this pattern had been going on for years. How I'd send payments on time, sometimes early, only to receive violation letters weeks later claiming I was delinquent. How I'd request clarification and get generic responses, or none at all. I told the court that at one point, my balance increased even after I made a payment, and when I asked why, the HOA told me it was due to adjustments. Adjustments to what? No one could ever say. The judge nodded slowly, writing something down that seemed to take longer than the rest. Then she asked the HOA attorney a question that clearly wasn't on his script. Who has direct control over the association's finances? He answered that the treasurer handled the accounts. Alone? The judge asked. Another pause. The attorney admitted the treasurer managed deposits, records, and reports, and that the board reviewed summaries during meetings. The judge didn't look impressed. So no dual signatures, she asked. No independent oversight? The attorney tried to argue that the board itself was the oversight. The judge didn't respond to that at all. That's when the HOA president couldn't help themselves again. They jumped in to say the board trusted the treasurer completely and had no reason to doubt the records. The judge looked directly at them and said, "Trust is not a financial control." That line hit the room like a gavel strike. She explained, clearly and methodically, that when an organization uses fines and penalties to take property or money from homeowners, the burden of accuracy is absolute. Not assumed. Not implied. Proven. The HOA attorney swallowed hard. Finally, the judge closed the file in front of her and leaned forward. "You are asking this court to enforce penalties based on financial records that have never been independently verified," she said. "You have no original documentation, no audit history, and no safeguards against error or abuse." She paused, letting every word sink in. The HOA's confidence was completely gone now. And then she asked the question that made the air feel heavier. Why should this court trust numbers that even your own board has never verified? No one answered. And for the first time, I saw real concern on the HOA's side of the room, because it was obvious now. This case wasn't about unpaid dues anymore. It was about what those numbers were hiding. The silence after the judge's last question stretched uncomfortably long. The HOA attorney glanced at his client, then back at the bench, clearly hoping for some way to steer the hearing back onto safer ground. Instead, he did the worst thing possible. He tried to minimize the issue. He said there was no evidence of wrongdoing, that this was simply a bookkeeping dispute, and that ordering anything beyond the scope of the case would be unnecessary. His voice sounded thinner now, less rehearsed, like he knew the ground under him was starting to crack. The judge didn't raise her voice. She didn't argue. She just started asking sharper questions. How long has this treasurer been in control of the accounts? The attorney answered, over 10 years. And during that time, the judge continued, has there ever been a full audit of any kind? No, Your Honor. Has anyone outside the board ever reviewed these records? No. Each answer made the room heavier. The judge turned her attention to the HOA president and asked if they disagreed with any of that. The president shook their head, suddenly very quiet. The judge then explained something that felt less like a warning and more like a lesson. When an association has the power to fine, lien, and foreclose on homes, its financial transparency must be beyond question. Anything less invites abuse, intentional or not. The HOA attorney tried one last time to interrupt, but the judge cut him off with a look. Then she leaned forward and said the words that changed everything. This court is not comfortable relying on unverified summaries in a case involving property rights. She paused, flipped her notepad closed, and continued, accordingly, I am ordering a forensic audit of this Homeowners Association's financial records, effective immediately. It took a second for it to sink in. The HOA attorney's face went pale. The HOA president turned sharply toward him, whispering urgently. One of the board members in the back actually said, "What?" out loud before catching themselves. The judge wasn't finished. She clarified that the audit would be conducted by an independent third party, chosen by the court, not the HOA. Every account, every fine, every deposit, every expense. No time limit shortcuts. No internal reviews. Full access. She also made it clear that until the audit was complete, the court would not enforce any fines, penalties, or collection actions against any homeowner. The room buzzed with quiet shock. This was no longer just about me. It was about the entire association. The HOA attorney asked for a brief recess to confer with his client. The judge denied it without hesitation. "We're already here," she said. "This is happening." I sat there in stunned silence. I had walked into court expecting to defend myself against a financial claim. Instead, I was watching the entire HOA unravel in real time. The judge's tone never changed, calm, controlled, deliberate, but the impact was explosive. She ordered the HOA to produce all financial records within a strict deadline and warned that failure to comply would result in sanctions. Real ones. As the judge moved on to the next item on the docket, the HOA side of the room looked completely different than it had an hour earlier. Gone was the confidence. Gone was the smugness. All that remained was panic, and the realization that whatever had been hiding in those numbers was about to be exposed. The panic didn't wait for the audit report. It started immediately. Within days of the court order, the HOA board called an emergency meeting. Notices went out late at night. The agenda was vague. Homeowners packed the room anyway, sensing something big was happening. The treasurer sat rigid at the end of the table, refusing to make eye contact with anyone. The HOA attorney attended too, unusually quiet, mostly whispering to board members instead of addressing the crowd. When homeowners asked what a forensic audit meant, the board gave careful, rehearsed answers that didn't actually explain anything. But the fear in their voices said more than the words. The auditors began requesting records almost immediately, and that's when the real problems surfaced. Bank statements were missing. Years of them. Expense receipts were incomplete or non-existent. Large transfers had no clear explanation. Some charges were labeled vaguely as administrative costs, but the vendors didn't exist. When auditors asked for original invoices, the treasurer said they were no longer available. That answer was repeated so often it started to sound like a confession. Emails flew back and forth as deadlines approached, and the HOA's attorney started asking for extensions. The court denied them. As the audit dug deeper, patterns emerged. HOA funds had been used for personal expenses, meals, travel, even retail purchases that had nothing to do with community operations. Fines had been selectively enforced, not to maintain rules, but to plug budget holes when accounts ran low. Certain homeowners were targeted repeatedly, while others were ignored completely. It became clear that the system wasn't just sloppy, it was being used as a weapon. Word spread fast, and homeowners who had been fined for years started comparing letters, dates, and balances. The stories lined up too perfectly to ignore. The HOA attorney finally requested another court hearing, citing unexpected complications. When everyone reconvened, the atmosphere was tense. The judge listened as the attorney tried to frame the findings as clerical errors and misunderstandings. She wasn't buying it. The auditors had already flagged multiple transactions that warranted further investigation. When the judge asked whether any of the board members had personally benefited from HOA funds, the room went dead silent. No one answered. The judge's patience visibly thinned. That's when she dropped the next bomb. She warned the HOA that if the audit continued to reveal misappropriation, the matter would be referred to state regulators, and potentially to criminal investigators. Not as a threat, but as a legal obligation. She reminded the board that fiduciary duty isn't optional, and ignorance isn't a defense. The HOA president looked stunned. The treasurer stared straight ahead, jaw clenched. The attorney said nothing at all. By the time the hearing ended, it was clear the HOA wasn't just fighting a lawsuit anymore. They were fighting to survive. Homeowners left the courtroom whispering, angry and energized. Some were already talking about refunds. Others were asking how long the board had known. And as the audit moved closer to completion, one thing was obvious to everyone involved. This story was far from over, and the fallout was about to be brutal. By the time the forensic audit was finalized, the HOA was already unraveling. The report was devastating. It confirmed what the judge had suspected from the very beginning. This wasn't a series of innocent mistakes. Funds were missing. Large amounts. HOA money had been used for personal expenses over multiple years, disguised under vague categories and unsupported charges. Fines had been selectively enforced, not to maintain community standards, but to cover financial shortfalls created by mismanagement and misuse. The numbers told a clear story, and it wasn't one the HOA could explain away. When the parties returned to court for the final hearing, the HOA side looked nothing like it had on day one. The treasurer wasn't there anymore. No explanation was given. The HOA president sat silently, eyes fixed on the table. Their attorney spoke carefully now, choosing every word like it might be used against him later, which, frankly, it might. The judge reviewed the audit findings on the record, page by page, highlighting the lack of controls, the unauthorized expenses, and the complete failure of fiduciary duty. There was no room left for argument. The judge dismissed the case against me entirely. Not only that, she went further. She ordered the HOA to immediately suspend all fines, penalties, and collection actions community-wide until a new, compliant financial system was put in place. She directed that the audit be forwarded to state regulators for further review and reminded the board that criminal consequences were not off the table. The courtroom was silent as she delivered the ruling. No gavel slam. No theatrics. Just finality. In the weeks that followed, the fallout was swift. The HOA president resigned. 2 board members stepped down quietly. Homeowners demanded answers and refunds. Meetings turned chaotic as residents questioned every charge they'd ever paid. Special assessments were canceled. Legal fees piled up. Trust evaporated overnight. What had once been a powerful board suddenly couldn't enforce even basic rules without being challenged. As for me, I walked away without owing a single dollar. What started as an attempt to squeeze me over questionable fees ended with the entire HOA exposed. The judge had seen through the paperwork, the confidence, and the intimidation, and once she did, there was no putting the truth back in the box. They came to court expecting compliance. They left under investigation. And that's how a few alleged unpaid dues turned into the complete collapse of an HOA that thought no one would ever look closely enough.